Yeah! You know who it is. Hey, don't ask who did it. Check the name, fool.
The associates did it, yeah, they rolling deep. The associates did it, got it out the streets. The associates did it, never miss a beat. If you heard some real ones, it was probably me. The associates did it.
Hey everyone, this is episode 9 of The Associates Did It. My name is Todd Cohen. I'll let everyone go around the room to introduce themselves.
Josh Carpenter,
Ryan Sherman, and James Metcalf.
Today's subject matter, we are talking about ChatGPT and the use of AI in the legal world.
holy cow.
The fun begins.
Don't do it.
All right, I think we're just kind of talking off air here, and Todd's going to pull something up for me, and I'm going to do a little bit of reading. Sorry, I know reading is not very exciting on a podcast, but it's going to happen anyway here. So we're talking about the case of United States District Court of Southern District, New York. This is Roberto Mata versus Avianca Incorporated. This is 22 CV 1461, if anybody really gets bored. All right. So I'm just going to read the opinion here. It says, in researching and drafting court submissions, good lawyers appropriately obtain assistance from junior lawyers, law students, contract lawyers, legal encyclopedias, and databases such as Westlaw and LexisNexis. Technological advances are commonplace, and there is nothing inherently improper about using a reliable artificial intelligence tool for assistance. But existing rules impose a gatekeeping role on attorneys to ensure the accuracy of their filings. So they go through the name of the law firm. I'll skip that part. But this law firm abandoned their responsibilities when they submitted non-existent judicial opinions with fake quotes and citations created by artificial intelligence tool ChatGPT. They continued to stand by those fake opinions after judicial orders called their existence into question. Many harms flow from the submission of fake opinions. The opposing party wastes time and money in exposing the deception. The court's time is taken from other important endeavors. The client may be deprived of arguments based on authentic judicial precedents, and there is potential harm to the reputation of judges and courts whose names are falsely invoked as authors of the bogus opinions, and to the reputation of a party attributed with fictional conduct. It promotes cynicism about the legal profession and the American judicial system, and a future litigant may be tempted to defy a judicial ruling by disingenuously claiming doubt about its authenticity. The narrative leading to sanctions against the respondents in this case include the filing of the March 1st, 2023 submission that first cited fake cases. But if the matter had ended with respondents coming clean about their actions shortly after they received the defendant's March 15th brief questioning the existence of the cases, or after they reviewed the court's orders of April 11th and 12th requiring production of the cases, the record now would look quite different. Instead, the individual respondents doubled down and did not begin to dribble out the truth until May 25th, after the court issued an order to show cause why one of the individual respondents ought not be sanctioned. For reasons explained in considering the conduct of each individual respondent separately, the court finds bad faith on the part of the individual respondents based on acts of conscious avoidance and false and misleading statements to the court. Sanctions will therefore be imposed on the individual respondents. Rule 11C1, this is under the federal code, by the way. Rule 11C1 also provides that absent exceptional circumstances, a law firm must be held jointly responsible for a violation committed by its associate or employee. Because the court finds no exceptional circumstances, sanctions will be jointly imposed on the Lebedeau law firm. The sanctions are limited to what suffices to deter repetition of the conduct or comparable conduct by others similarly situated. I'm going to skip ahead a little bit, and I just want to, they take a little testimony that we read down here. Paragraph 12, it said, Mr. Schwartz testified at the hearing that he knew that there were free sites available on the internet where a known case citation to a reported citation and decision could be entered and the decision displayed. He admitted that he entered the citation to Vargas or whatever, however you pronounce that
I
case,
would know, yeah.
but he could not find it. So this is a transcript of the court questioning the attorney. The court, did you say, well, they gave me a part of Vargasy. Let me look at the full Vargasy decision. Mr. Schwartz, I did. The court, And what did you find when you went to look up the Varghese decision? I could not find it. And yet you cited it in the brief to me. I did, again, operating under the false assumption and disbelief that this website could produce completely fabricated cases. And if I knew that, I obviously never would have submitted these cases. The court issued an order directing Mr. Laduca to file an affidavit that annexed copies of the following decisions cited in the affirmative opposition. And the order, I'm skipping all the case sites, and the order stated failure to comply will result in dismissal of the action pursuant to Rule 41B. And then subsequently, they issued an order that he was to annex the additional decision, which was cited in the affirmation. And anyway, long story short, they just said he needed to provide proof that the cases were real.
Yeah, I like the fact he doubled down, like he wasn't going to get caught or something.
And skipping down a little bit, he did execute and file the affidavit on April 25th that annexed what were purported to be copies or excerpts of all but one of the decisions required by the orders of April 11 and 12th. And to that, he said, I was unable to locate this case, which was cited by the court in Varghese. And then his affidavit stated that the purported decisions may not be inclusive of the entire opinions, but only what is made available by the online database. So he just kept doubling down his yeah, it was a fake case and
fake case inside a fake case.
So it just kind of goes on and it talks about this. And the reason why this is all relevant, that's kind of the end of what we're going to read, or else we could be in here the rest of the day.
Yeah, it's 43 pages.
But very, very infrequently do you see language like that's shown in here. And he's like, the Varghese decision shows stylistic and reasoning flaws that do not generally appear in decision issued by United States Courts of Appeals. Its legal analysis is gibberish. It references a claim for the wrongful death of George Scaria Varghese brought by Susan Varghese. It then describes the claims of a plaintiff named Anish Varghese who, due to airline overbooking, was denied boarding on a flight from Bangkok to New York that had a layover in Guangzhou, China. There's no way I pronounced that right, by the way. The summary of these cases' procedural history is difficult to follow and borders on nonsensical, including an abrupt mention of arbitration and a reference to plaintiff's decision to file for Chapter 7 bankruptcy as a tactical response to the district court's dismissal of his complaint. Without any relevant explanation, Varghese later references the plaintiff's Chapter 13 bankruptcy proceeding instead of 7. And the Varghese defendant is also said to have filed for bankruptcy protection in China, also triggering a stay of proceedings. Quotation marks are often unpaired, which means just open-ended quotations. The Varghese decision abruptly ends without a conclusion.
But I got the case law needed, so I'm moving on.
It has a case number related with a completely other case, and the Federal Reporter is associated with yet a different case, and includes internal citations and quotes from decisions that are non-existent. So they had fake cases inside of fake cases inside of fake cases. God bless ChatGPT.
Yeah.
Now, this is really relevant. We've kind of associated this. We've spoken about this a little bit more. By the way, if you're drinking while listening to this podcast, we have noticed that if I say at the end of the day, you should take whatever drink of your choice, because apparently I say that a lot. And so
You might be pretty inebriated afterwards, so make sure you're not driving.
drink Sprite or something.
Yeah. Be nice to your liver.
But we had a case, and it was a tens of millions of dollars apartment complex case. And in the state of Texas, a company has to be represented by a lawyer,
Yes.
right? It cannot self-represent. And so the owners of this company came to us. Litigation was ongoing, and they hired us to represent them in court way out somewhere in West Texas. And prior to our entry into the case, the CEO had persisted in filing a number of pleadings. I think there were 6 or 7.
Yep.
A number of pleadings that had been constructed, later found out, that had been constructed completely through ChatGPT. And if you read them, they made no sense.
Right.
And if you knew how to read, they made no sense. If you did not know how to read and somebody read them to you, they would still not make any sense. And so we went to court, and by the time that we ended up having a pretty heated exchange, and we got kind of crosswise with the client because they didn't want to use applicable law. They wanted to use ChatGPT, which
Right.
not a thing, by the way. And so we went to 2 hearings on this case. The second, which was a motion to withdraw of
Yep.
ours.
Yep.
And so what's really interesting is the CEO was sanctioned by the court for using AI. And as a personal note, I think that's the first time anybody in our law firm ever had to deal with that issue. And this was a year and a half ago.
Yeah, that was me.
And and so a year and a half ago was the first time we'd ever really had to deal with this AI thing. And what was interesting to us is it wasn't as alarming at this point because from what I recall, she didn't have fictitious cases, but her analysis and her directives was just all over the place. And so,
yeah, it gave that basically gave the opposite conclusion. Like, for instance, it was like a grant. She would say it granted, and then the court was like, "Well, it actually didn't grant this issue, so it doesn't have anything to do with your case."
This reminds me, complete side war story. I was in court here in Texas, and I had an argument in front of a court in Collin County, and the argument went back and forth. I was just defending, obviously disagreeing with the opposing counsel. And we were arguing about 2 specific cases, back and forth. And I noticed the judge just had a very peculiar look on her face. And the case was going back and forth. And I was arguing pretty strongly from in reviewing the case and the case law and the context and everything else. I was arguing that case in one way, the way I thought it actually read, and the other attorney was arguing the case in what I would describe as fanciful magic wand wannabe lawyering,
Right.
which is they took 2 or 3 words, maybe a sentence out of an entire case, and they were trying to bend that case to their wants and needs in their own case. So we went back, and it was literally almost an hour and a half of straight oral argument, which for people listening, that's not very common.
No.
You don't typically argue that much and go back and forth and cite case law and then move forward with an offer of proof and or opening or some type of statement and then start arguing and objecting. That's not very common, right? It's usually a few minutes here and there or whatever, but this was brutal. And at the end of the hearing, I won, by the way. But at the end of the hearing, the reason I won is because the judge finally stopped us and she said, "Counsel, I don't know if you realize, but I'm pretty familiar with this case because I was the one that argued it." That kind of slammed the door on a lot of the argument. And the reason I won the case is because I was trying to use the context of the full case.
Yeah.
And the opposing party was trying to bend it to what they wanted. And the judge did not appreciate that because that's not at all what the case, in my opinion, and the judges, frankly, that's not what the case was standing for. And so it was pretty fantastic that the judge just stopped after a while and she's like, "This was my case."
If you scroll up to the headers, it says "argued by." There's my name right there.
Yeah, so switching back to this case out west, what was interesting about this as well is that didn't necessarily happen, but I think we in the office and prepping for this case, and James, when he was out arguing it, there was a couple aha moments where we realized that a lot of the things that she had been citing were literally just made up.
Yeah, and I remember telling you, like, we're past date of amendment. We have a hearing tomorrow morning.
Yeah.
I can do nothing.
And we tried to get her to do the right thing about it and everything else, and she just wouldn't have it. And because she was persisting on, this is a slight off-topic thing, but because she was persistent in trying to commit fraud upon the court or deceive the court or have lack of candor or however you want to characterize it, we ended up having to withdraw, happily, by the way. And but it was an interesting time because that's the first time in a year and a half out of 2.5 decades that we've ever had to deal with artificial intelligence written information.
Right.
Right. Credit to that opposing counsel in that case because I was getting I was getting taken behind the woodshed for it. And the court, I mentioned the court saying, "Your Honor, I have been retained as of 2 days ago. I am not familiar with this. I've familiarized myself with this motion. I can't attest to what is and is not in here. As you can see, is filed by a pro se." And the opposing counsel goes, "I am not saying any of these issues against Mr. Metcalf because I don't know if I can't confirm his retainment, but he himself did not write this, did not file this. So if you're going to issue any sanctions, I ask it not to be held against him or his firm." And I was like, "Thank you so much." Like,
That's a
I was
good
like,
man.
"We're battling, but you're at least showing me some niceness of going, it wasn't him. I don't have the fire against him. It's against that person over there.
Right. Yeah, from my perspective, I graduated law school in 2020, and I hadn't heard of ChatGPT maybe until a couple of years into my professional life, maybe 2022. One of the other lawyers that I was working with, he actually introduced it to me. And for us, it was an amazing new tool on like how to organize information and stuff like that. I believe ChatGPT, I don't know, James, if you know off the top of your head, but I think it was maybe started in 2017 or 2019 as like a non-profit, like open source sort of.
It was some kind of cool tool to use better than Google.
But like they had stopped aggregating data at that point. And then I know at some point they were, purchased, they were bought out and it turned into a public company, and then they started aggregating data again. And so it turned into this, big machine over the last 3 or 4 years.
Now it's everything.
And so now we're seeing it all day, every day. I mean, so the first instance that we encountered it was what James was describing. But I mean, just this morning, you and I were briefed about an attorney that we know of who is being accused of using ChatGPT to write an affidavit, even though it was clearly it was not a AI written document.
Well, what was funny about that is the judge. This was in a small town in Texas as well, but the judge was expecting it to be written in, I guess, small town Texas parlance.
Right.
And the attorney that wrote it very effectually, very, very well written. And so the judge believed it was written by AI instead of a person. And so the attorney got kicked out of court on this matter, told to rewrite the affidavit and come back later.
So that brought a question to my mind.
And that's just today.
To even allege it, should there be some type of forensic, run through of determination whether it's AI?
That's the issue, because it actually, I've actually looked this up because there's some pro se's we've gone against.
Right.
And I'm looking at, and I've looked at the pleading. I'm going, I don't think he or she wrote this. And I started Googling back and forth. Can ChatGPT recognize its own written document? It can't, because it's basically a closed world with whatever person is using it at that point.
Yeah.
And once it spits it out, it's just like an etch-a-sketch. It's from its memory.
But you have programs that it can check, right?
Yeah, it can detect for AI patterns, but I don't think it's ever 100%. I think it can only
you can't verify specifically until like the case you were reading right there, Josh, of we looked into these cases and they're not real.
But just so everyone's clear, you don't need AI to determine what ChatGPT looks like. There will be random words bolded. There will be hyphens and dashes between words. There will be lines between paragraphs.
Yeah.
It's very apparent on its face when there's a ChatGPT produced document without any modifications or edits.
Well, we're sitting here talking quite a bit about this,
Right.
but we actually have an in-room quasi-expert about AI at this point.
At least someone who's confronted this issue multiple times recently.
Yeah,
Our good old handsome Brian has recently briefed this issue and filed on it, I think, 3 or 4 times already. So Brian, teach us, my brother.
Well, I think what's happening now, before we even get into what the things that I filed, is you're starting to see courts and jurisdictions release their own standing orders asking attorneys and pro se litigants to verify and attest to the fact that they are, if they have used an artificial intelligence engine to create a pleading or a document that's before the court, that they've actually checked it and that they've actually gone to real live legal sources such as Westlaw or a law library and said, hey, this is what we purport it to be. It's genuine. And it's very interesting to me because, like, Denton County now has a standing.
Oh yeah, they'll reject your thing if you don't.
Yeah, you have to acknowledge this attestation and that you've done your homework on it. I think what they're doing is they're setting themselves up to start sanctioning people because I think it's an abuse of the court's time. It's costing taxpayers a lot of money.
Mm-hmm.
It's costing law firms a lot of money because we have to respond to these. If there's a motion before the court and it's filed, to me, it's like kicking an ant hive, right? So it's like I have one case where if I so much as file one thing, the pro se litigants on the other side file about 4 or 5 motions in response to my motion. And they come up with the most, it's just a big bottle of chaos that they throw at the court. And I have to
for the court to say he's
I-
a poopy head. That's not a real motion.
do I need to even respond to this? And how much am I going to charge my client to respond to these frivolous pleadings? And the one thing that always shines through in all of these ChatGPT motions is that I can pick up in an instant that these are made by an artificial intelligence engine. There's either a couple of elements to a cause of action missing. There are fake causes of action that in 25 years I've never seen. One of them recently was called Hitman Theory, was asserted against us in a specific petition that
You don't
was
even know, Brian, it's real.
I've just have never, yeah. What is the cause of action and the elements of Hitman Theory?
I'm curious now. Let's see this.
So, I mean, they're kind of laughable to us, but ultimately we sit here with our clients' retainer money saying, how many hours am I going to throw at this to respond to these frivolous motions? And I think the courts are catching on to it now.
Well, the term vexatious litigant is catching a lot more wings lately.
Yeah.
Yeah, and so what I have done in my motions is in the Northern District Federal Court here in Texas, Judge Brantley Starr has a standing order that I think really summarizes it well. And so I actually quote the clause out of his motion or out of his standing order at the before I even get into my arguments. I just stick it up there.
Yeah.
At the very beginning of my motion.
Just take a bow like
I have it
Judge.
right
I
here,
quote
this
to
one.
you.
And you can see what I did.
There
And
it is.
I quote it in the beginning before I even start the comes now Carpenter and Associate, whoever it is. And I want them to know that I'm on to them from the beginning.
You should
and
read
then,
it because it's pretty good.
I'll read it to you. So this is Brantley Starr, U.S. District Court for the Northern District of Texas. This is his standing order. This came out in 2023. He states that all attorneys and pro se litigants appearing before the court must, together with their notice of appearance, file on the docket a certificate attesting either that no portion of any filing will be drafted by generative artificial intelligence, such as ChatGPT, or that any language drafted by generative artificial intelligence will be checked for accuracy using print reporters, that's called books, or traditional legal databases, such as Westlaw, by a human being. These platforms in their current states are prone to hallucinations and bias. On hallucinations, they make stuff up. And I put that in italics, so it's called out on hallucinations, they make stuff up. And then I use hallucinations in I have an actual argument on hallucinations in my motion. So I'm using this against them. In fact, I'm getting to the point where I actually like it when I see this because I know that I can wind up, and the courts are getting fatigued from seeing these motions. That doesn't mean you can't go educate yourself the best you can by using the internet and resources and artificial intelligence. I certainly think there's some better platforms out there. I think OpenCase.ai is connected to the Cornell School of Law.
Right.
And I think that tends to be a lot more reliable. But when I say more reliable, I don't mean that it's fail-safe and that everything should be checked. But either way, I see these things now and I wind up on the other side because at some point it's time to start asking for sanctions, because if it costs me $2,500 to respond to this, and it's completely made up of fake case law and often fake theories that I've never seen in all my years of practicing law. If I have to respond to it, I want you to pay for me to respond to this when it's said and done.
Oh
Can I read this from Thomson Reuters real quick? It just directly applies.
No, I cited that case in this motion. I have that citation in here.
So it says, the case that we're talking about also, it says, as the legal world marches on towards 3 years with generative AI in the public sphere, one key risk has arisen above all others: hallucinations. These hallucinations are false facts generated by Gen AI systems and can occur due, there are typos in here, and occur due to a number of issues, including incomplete or inaccurate data sets, confusing or misworded prompts, or answers that are irrelevant to a given question. It is clear that no matter a hallucination's provenance, however, the possibility of a false fact has slowed Gen AI's growth among legal professionals. Among respondents to 2025 Generative AI and Professional Services report, who said they felt Gen AI should not be a part of their daily work, 40% cited accuracy and reliability as their primary concern, nearly double any other major concern, including a lack of human touch, generality of outputs, or biased data. Perhaps this should not be a surprise given continued press coverage around hallucinations. Even with accuracy top of mind, AI misuse is continuing with regularity in courts across the United States. In fact, a recent study of cases across the United States for the month of July found numerous false case citations, leading in many cases to attorney sanctions or discipline. And we actually had a list. We read the first New York one, but this is exactly what Brian's talking about. Is it just makes stuff up?
Cited right here, Reuters.
There you
The
go.
very article you're referring to.
February of 2025 is when that came out.
That
By
was
the way.
wild.
Yeah.
So, you know, and to that end, Brian brings up an interesting case because we have a case right now where there's a pro se party,
I was gonna bring this up.
and the pro se party that just means somebody with no lawyer, right? They're acting on their own.
Which is your right.
This party filed approximately 30 pleadings in a couple months. 30 pleadings that each pleading was approximately 10 to 20 pages long, completely AI generated, and just repetitive, continuing to assert the same cases, continuing to assert codes, continuing to assert arguments that were just false and inaccurate. And aside from that, we've also had our own clients that demand that we follow ChatGPT
Strategy.
objectives and strategies, and they don't seem to understand that it's not even real. They're not even understanding the very foundation or basics of the legal argument, and so they are of this opinion that they know they can do. They are the superhuman brain because they got ChatGPT in their ear, but they're not listening to us. They're not listening to the law. And so it's caused a lot of problems for both sides of the aisle from us with opposing parties, but it's also caused problems with our own clients.
I think that is especially true in a recent situation here where we had one of our clients checking our work
Oh,
and claiming that he had independent legal counsel review what we did, and he thought that we were not following the law.
Right.
And he offered this stuff to us, and we can see right through it. And so in this situation, I saw it, and I was so concerned about it that I ran up here on the weekend to craft an email back to him, and I said, I need the name of your lawyer and law firm. I'd like to talk to them about these critical issues that you have found in my prosecution of your case. It's really important. Now, I knew all along that it was probably ChatGPT that came, and I had now caught our client essentially lying to us. But it's a dangerous tool to use. I think if it's used appropriately, you can absolutely use it to raise questions and have a really thoughtful conversation with your lawyer and use it as an assistance in that sense. But if you think that ChatGPT or any of these AI engines are giving you true legal theories to stand upon, you're really going down a dark path. And with this client, he just could not get it through his head that what he found through a few mouse clicks and his independent law firm called the Law Offices of ChatGPT.
It's official.
That
Sounds like it.
licensed and passed the bar. I'm
They're
sure.
always open.
Yeah, and they're ready for business at any time. He just had a hard time swallowing it. It really threw off our chance to do some good things for him. So,
I mean, yeah, because so we've been trashing it. ChatGPT has a lot of good uses. I actually found out that one of our colleagues here, what he will do, he'll put some of the facts of a current case we're working and put it in there and ask it what would be good questions of documents to prove this fact that you need from the other side. And it spits out questions for discovery. It's like, that's a good use because it gives them ideas. It's like, oh, I can make that a question, or I can kind of make that a two-part question or something. That's a fantastic use for it because it sees it from all ends that maybe our brain just can't see it from. But to use it and just say, spit me out questions and then just copy paste it and that's it, you're going to end up in a whole mess of trouble. Or you're going to get discovery responses back going, no documents. I have no idea when you asked this, by the way.
yeah. Well, I think there's good also in the sense of like legal transactional work, which I do a fair amount of. When I'm drafting a company agreement or some corporate governance, yeah, I'm on. When I'm drafting corporate governance documents, sometimes I'll put the file into an AI engine and just say, hey, have I drafted redundancies in here, or are there things in here that might be in conflict with each other and I need to go back and revisit it? But the key there is that I go back and revisit it once it points that out. So sometimes it's just a good checker of my work, and I found that it's very useful in transactional work for that reason.
Right. I found some of the most recent like first year right out of law school associates have they've all like used ChatGPT within law school, and they're now talking about it within law schools. And so I find it interesting, like, the younger generation of lawyers are particularly who's either going to have to overcome using it themselves or, be dealing with this for the rest of their career until there's some sort of stopgap put in place. The entirety of their careers, possibly. I sort of wanted to bring up the most extreme example of ChatGPT that I've observed, or inappropriate ChatGPT or AI usage that I've observed, which, boils back down to the term that Josh brought up a minute ago, vexatious litigants. ChatGPT allows people to draft, dozens of pleadings at a time if they want to. And
And letters.
we've encountered a
And
case and situation where I don't recall if there's either over 600 pleadings or over 600 pages of pleadings.
636 now pages of pleadings.
So, who knows how many that is, if you count up all the pages. But an obscene amount of filings into a case. In this situation, it's a family case. It's heavily contested. There's a lot of stuff going on with it. But the person involved, they've caused a huge problem for themselves to the point where he's facing contempt and he's facing, criminal actions, basically. So I don't know.
So I believe the court has seen through the ChatGPT motions as well.
Well, the court's already sanctioned him for it.
Right.
And so it's just.
And our job is to try to unwind it, and we couldn't unwind too much.
Because he wants to listen to ChatGPT instead of his lawyers.
Correct.
But really what's the most dangerous part about this is no matter what evidence has been presented, explaining how things are really done and everything else, he's refusing to believe that, and he is completely focused and borderline addicted, you might actually say, obsessed, addicted, whatever you want to say, with what ChatGPT is saying. It's actually kind of a bizarre. It wouldn't surprise me, candidly, if in a few years, OpenAI has been available for 3 years.
Right.
Mm-hmm.
In 3 years, it's ruined multiple professions. It's also helped a lot of cool things too, right? I know the acting profession is up in arms because they're going to start losing actors and they're going to be replaced pretty seamlessly from all statements.
But I know in software development, it actually helps a lot because it can do an automatic test right there, and they can say, "Oh, the error code's here, here, and here. Oh, fixed. Boom, done."
Yeah. But even like for us, like I know a lot of people in this law firm and other law firms can use it just real quick to check things.
Mm-hmm.
But then once again, the secondary stuff that's required of us is if it says, "Oh, that's found under Rule 63." Well, you still have to go to Rule 63.
Yeah. Flip the book open, read it.
Look at it. Look at it with your own eyeballs, right? And so in this particular case, it's so dangerous because this man is affecting the life at this point of probably 24 people.
Right. Exactly.
And he is essentially holding people hostage. And the court and all these other cases that he's involved in, what is the court really going to do? And the problem is none of us really know. We all have strong opinions.
Yeah.
But if you go back, the problem that you're running into is he has arguably a right to file whatever he wants to file.
Correct.
And he has a right of due process, and he can file notices of hearing, and he can do all these things. Okay, fantastic. But what we don't really have as lawyers, what we don't have a clear picture of is where is, in fact, that line.
Right.
And I know a lot of people are going to laugh about what I say here, but I don't know if you guys even remember this. I'm sure Brian does. But when the Supreme Court had to define pornography.
Oh, I know it when I see it.
Yeah.
Yeah.
Right.
Yeah, absolutely. So that's one of the things that who knows what that? Yeah. Who does? To this day I don't even know what that means.
Yeah.
Right.
Well,
But AI is the same way because all four of us have we can pick out ChatGPT pretty readily.
Right.
But when we're talking about an actual formal court proceeding, and we're talking about people using ChatGPT to draft pleadings and everything else, how do we, as lawyers, judges, and I wish Judge Harris was here because this would be a good question for him. How do we know where the line is and say, Your Honor, this is his 42nd motion today.
Yeah.
or whatever the case might be.
Right.
Like this is craziness.
Please
I-
issue sanctions this time.
Yeah.
Please.
Where do we draw the line? Because even the term vexatious litigant, does anybody want to take a spin at at explaining that?
No.
Okay. Very, very quickly, very
We're out of
briefly.
words.
A vexatious litigant is a title that you can put on a party in a case, and it restricts intentionally their ability to file pleadings.
Mhm.
All right, so they have to get the court's permission essentially to file things.
Oh wow.
Right, and it's
That's a heavy like threshold to meet because you're
Right.
like you said, you're taking away their right to file what they want to file.
well, and I've also seen it where the court requires them to obtain counsel or have an independent attorney sign off on that motion. I've seen it done a few different ways, but in this particular instance, I don't know how else you could manage the level of litigation and motions, because there's one thing to file a bunch of motions. Secondarily, there's a process to get a motion heard.
Right.
So Todd, if you wanted to file a motion to modify some order, it doesn't even matter what kind of order, what are the typical steps that you would follow?
For filing,
And getting into the court?
well, after drafting and getting approval from the client and whatever attorney is related to that, and finalizing and getting actually prepped for filing, I would use the e-filing Texas manager, and I upload a copy into that. I double check it for accuracy. I make sure all appropriate parties are copied as service contacts, and I'd submit and file.
Okay. And then how do you actually get heard by the judge?
You would have to reach out to the court staff, particularly the court coordinator. Usually, different counties have different jargon for it, but you'd request for hearing dates. Some counties actually have just lists of standing future hearing dates that you confer with opposing counsel first beforehand, and then you reach out to the court. But typically the process is you should reach out to the court with opposing counsel copied, let them know that you're looking for a hearing on this motion and request for dates. You confer privately with opposing party or opposing counsel, and then you confirm with the coordinator which date selection works for you both.
And then you file a notice of hearing.
Yep.
Usually.
So depending on the court, not just the jurisdiction, but depending on the specific court, that can be really hard sometimes.
Right.
Because secondarily, tertiary to all of that, there are a lot of court dates that are 6 and 8 months out.
Sure.
Right.
Gosh,
And
yes.
so, and that's not even trial dates. If you want to talk about a trial or multi-day trial, literally we're getting calendar dates in 2027 already, right? Towards the latter end of 27
Yeah.
for that matter. And if you want a jury trial, like a 5-day jury trial in a civil case, they might be in 28 at this point, candidly, because Dallas is growing and it's busy, right? And so the problem that we're running into with all of those things is some of these parties will file endless motions, but they don't know how to actually get a hearing and get it set.
I see, yes.
And so then they think it's a conspiracy that they're not
ruling
getting
on
heard.
motions. Yeah.
But they haven't taken all the other steps Todd just outlined. They haven't set the hearing. They haven't gotten the hearing set. And so they've filed 27 or 30 hearings, but they can't get them set. And so
Well,
that
even-
creates additional problems because then they file additional pleadings for not getting hearings set. And it's become honestly a nightmare. Brian was talking a little bit about some of the cases that he's dealt with. He had to defend a pro se petition that I think had 17 or 18 causes of action. And from what I recall, I think only 3 of those causes of action are actual legal causes of action.
Well, there's also several causes of action that were criminal causes of action that would be brought by the state of Texas, not
Right.
an individual
That's
civil
civil
matter.
cause of action.
So that was sort of a tell for me that this was done by artificial intelligence when I see criminal theories being pled in a civil case. And so I'm like, okay, so we're going to have some fun with this guy. But to kind of put a bow on it, I think really what's going to end up happening, this is just my hunch, I think that at some point the judges are going to get exhausted from this, and I think that we're going to see legislation. I don't know, in Texas we have tort reform, we have their limitations on certain damages, we have certain thresholds to bring certain cases, whether it's hiring an expert to prove before you file that you actually have a cause of action that can stand on itself, that is ripe, that is ready to go. I think that we're going to see some sort of legislation at some point that's going to really ding people for filing these frivolous pleadings that have not been checked. And that's not to say that people don't use these artificial intelligence engines to create fantastic pleadings,
Right.
and
Right.
that they're really awesome. It's just
And another positive note I'd like to say is it does help clients communicate with us more effectively at times if they don't know how
Yeah.
to organize their own thoughts or articulate, you know.
It can help, but it's a tool only.
Right.
It's
But
not the end game.
Well, it's like the misinterpretation of Google. I mean, we've lived with it for a long time now, so it's ubiquitous. When you think of search, you think of Google it. It is a search engine, after all. It is not an answer engine. Even their now little AI thing at the top says, well, what we've kind of sifted through, and what it's kind of saying is this and this generally, but you might want to give a link to it, but you might want to click on this link to go to what it's talking about with this. Right, because it's taking its best stab at it. It's not saying this is absolute truth.
But this is going to permeate into all other industries where there could be lawsuits created out of it, such as, my wife being a physician, she says that almost every patient comes in with a ChatGPT printout of what their diagnosis should be to see if it matches what she says.
I have
So what is
cancer.
the
No,
WebMD
you have an
now?
ingrown toenail.
Yeah.
That's it. It's
So-
okay.
WebMD, I don't know how many times on WebMD I can have cancer.
Yeah.
The answer is all of them.
But how do you
Did you inhale glue once? Oh, you got the cancer. No.
but how do you handle that when you know what the diagnostic standards are for these conditions in the medical community that you belong to, and now you're coming in with somebody that's questioning it because they put in a few search terms in this, and so now she's of the thought that, hey, these people are going to come after me if they don't think that my care matched what ChatGPT says, and
But
I've
they
now
are.
violated the standard of care, which is not the case. So
What it's going to lead to is every intake appointment that physicians conduct is going to have to be recorded in some manner or another, and it's going to have to be HIPAA protected and recorded in some electronic vault somehow. But it's not going to stop at doctors. It's going to be for everything from lawyers, doctors, to guys fixing tires, to everything else. Like, well, you're a mechanic, but ChatGPT told me this. Like, we're at a weird kind of place, in my opinion, that I didn't see coming. I mean, this is like, it's not as like the Terminator movies, but almost electronically, it's getting kind of there. We're kind of at war in our profession. We're at war with fake information that people all believe is true.
But it goes back to just
We
a
need a team of
general,
us.
what is the standard of care in whatever industry you're in? And can ChatGPT question it to a true professional in that industry? And if you start weaponizing people against the professionals in those industries, they're going to believe that the standard of care was breached, that they didn't uphold it. And so I think we're going to see litigation based on this. And I think that we already see pleadings and court filings based on it. I just think at some point there's going to be a reckoning, and there's going to have to be some legislation on where this is all going to go.
And the issue with the legislation part is because, as we've just talked about here, AI over 3 years has changed, immensely.
Yeah.
From I can't draw hands to now I can draw a whole, even a commercial of nobody in there is real. It all looks good. So legislation is going to have to be so detailed, probably have its own legislative session for Texas, if we're going to by state, just to determine what the language is, because it changes so much. They have to leave it so open-ended in a way to where, like, great, now I get to litigate over what this word means because they can't put it so defined.
Yeah.
Because tomorrow it changed to a whole different thing.
Everybody is a ChatGPT lawyer, a ChatGPT doctor, a ChatGPT, name your professional industry.
Well, also, I think it's going to start messing around with people who get complaints to the bar, and there, in some instances, it's a understandable and true complaint that needs to be settled because maybe the lawyer really did just mess over their client, not care about him, whatever. But you're going to have clients that say, "Well, it didn't follow my instructions, so this person is hurting his client," and now bar complaints are either going to be rifled out with no second look whatsoever. And so lawyers who actually need to be brought to certain kind of discipline for actions they actually did, they may not get away with it because you say it so much. Now it's basically the story of you cried wolf. Everybody's been doing it, so I don't believe you anymore. So you have to show me like something so over the top for me to even think about going to the next level for this disciplinary action.
Well, and I'm sure it's already happening, right?
Mhm.
I don't know for sure, but I'm supposing that it's happening with us,
Yeah.
right? And we're a medium-sized law firm in one town in an entire country of 320 some odd million people, right? So I can't even imagine what's going on in other professions and everything else. Like, I mean, I've been in law enforcement a lot of my life. I can't even imagine what people are dealing with on the law enforcement front at this point in just the last few months, because everything is changing constantly, right? I wish I did not ask ChatGPT on how fast AI is advancing, but it's advancing a lot. Like every other week, something is happening, some new software is happening. I mean, look, I will come clean right now. The intro music to this podcast itself was generated through AI, right? Because despite the fact I've been a musician my entire life, at a pretty high level, I've been a musician my whole life. I play the sax, alto and baritone
Get
sax, and I
scholarship
sing.
for it, man.
Yeah, man. And man, music was my life for a long time. And despite that, I was not blessed with the ability to write music, right? But
Todd looked it up right there.
Yeah.
Apparently, it doubles every 8 months.
that is horrifying. Every 5 months.
The compute power for AI doubling every
Oh, there it is.
5
Okay.
months. Data sets are doubling every 8 months, and power use is increasing annually, according to Google AI.
This is faster than Moore's law original pace for semiconductors. So, like the prediction for Moore's law, it's going faster than that. Granted, he couldn't have seen what we know now, but still, that is terrifying.
It is.
Yeah, because I mean,
Pretty soon you're going to hire some AI attorneys because they're cheaper. They work
So-
for free.
so there's a man named Mirza Faizan, and he's a friend of ours. He is for lack of a better term, he was a quality control rocket scientist for NASA. He's won all sorts of prizes. He runs a school right now for science and innovation and everything else. And he actually has a presentation that we should get him on if we can, because what he talks about in his presentation is exactly what we're talking about. He 5 years ago, because of what he does, he predicted the rise of AI and the rise of robotics.
Mm-hmm.
And so because of that, he created a school that focuses on looking at education and teaching kids in a different way.
Yeah.
And so that education focuses on innovation. And he even says in there are only a couple jobs in the world that will not be significantly impacted or will not be significantly reduced by the rise of AI and robotics. One of them is lawyers, but at the same time, artists and musicians and everything, anything that requires significant creativity and innovation mentally is a little bit safer from AI, because that creativity and that kind of, for lack of a better term, these are my words, not anybody else's, that analog version of beauty in whatever form, whether it's
Right.
writing, whether
Right,
it's
because
art,
poems
or
can be
music.
written by computers
Right.
that didn't have touch, taste, feel, anything. So
Right,
it wouldn't
they
make sense.
can, but they're hollow, right?
Yeah.
But so he's created an entire school to try to teach kids, and he's amazing at it, by the way, because I think almost every one of the kids that go to this school have their own patents, and these kids are like, I think they're 10 to 15, 10 to 18 years old.
Little Sheldons everywhere.
Yeah, they have patents. They're creating exoskeleton, like robotic exoskeletons to help paraplegics and things like that. These are kids in junior high
Yeah.
that are doing this, and it's because he's helping them focus on innovation and training their brains to look at things just like I know they can't see, well, I guess they can't see that. The picture here, just kind of the creativity and getting outside the box and thinking and approaching things differently. There is rapidly becoming a lost art to this.
Mm-hmm.
And I know we've been going a long time, so I'll kind of shut us down unless anybody has something very poignant to say. But the difference between us and a computer is hard to tell sometimes.
Mm-hmm.
And it makes me think and harken back to the old story of John Henry. You know, John Henry could hammer, he could whistle, he could sing, right? But they created a machine that could work faster than man. And so nobody could work faster than John Henry. And so they made a test. They created a race between a track laying machine and John Henry, and who could pick and shovel and lay track faster.
Right.
I know this is an old song.
I
I've
know
got
it.
that Harry Belafonte version echoing in my head right now. But, it talks about the value of mankind in this story, and mankind being triumphant because he beats the machine, but he works himself so hard, he laid down his hammer and he died
Mm-hmm.
at the end. And I think the general concern of anybody being affected by these things is that the machines have changed now.
Yeah.
We can't beat the machine anymore. We can't possibly churn out 27 pleadings in a month with no import of what's in them. because our licenses would be ineffective. Our ability to support our families would be essentially nullified. Everything about who we are would be gone. And so, as we are our own versions of John Henry fighting against ChatGPT lawyers, as your wife and other physicians are fighting against ChatGPT doctors, as people are out there fighting against AI in general, at the same time, it's hard to not recognize that it has had pretty significant benefits. But those benefits are going to have to be bounded somehow.
Right.
The courts are going to have to figure out how we can limit pleadings. The courts are going to have to figure out at what point we just have to stop using these things and go from the innovative minds of ourselves before we're completely overrun by pointless, factless, hallucinogenic pleadings. And I guess what we're all kind of talking about here and worried about is we do not have an answer for that yet.
No.
We have a couple standing orders, but the problem with even the standing orders, ironically, is by the way some of them are worded, if you use an electronic signature at the end of that, you might arguably be using artificial intelligence to affirm that you're not using artificial intelligence.
Yes.
And so it's kind of this tautological issue that there's not going to be an answer to until we figure out collectively like what limits we're willing to place on AI. And we have to figure out truly, all right, well, is it worth having a human cashier, or are we cool with a robot? Do we want to check ourselves out at the box store or whatever else we're doing, or do we need to have somebody there if we don't know the specific code for a green pepper?
Yeah.
Or is it worth having a lawyer that actually knows what the law is and can make an argument, or do you want to just let people run willy-nilly with ChatGPT in their pocket and go to the courts and say and do whatever they want, which is going to make the practice of law impossible because nobody will be able to afford to litigate. They can't.
No.
Because what's going to happen, I don't care if it's Walmart, right? How many lawsuits are filed against Walmart every day? Honestly, across the country, probably thousands.
Oh, yeah.
Probably thousands. And people get really mad when you litigate against Walmart because if it's over $75,000, I'm not even going to prep you guys for the answer. But if it's over $75,000, what do they do 100% of the time that we all know?
Federal court.
They remove it to federal court. And they
Now
do that.
slows it down.
Yeah, they do that. Well, it slows it down in one aspect, speeds it up, but it also is more difficult to practice in federal court because a lot of the smaller personal injury lawyers don't want to practice in federal court, so they don't press the case.
Right.
They drop it or they settle it for a lot less or they just walk away. And so it might be a tactic, but it's a smart one because they get hammered all the time with different lawsuits. But for us, for the lawyers in general, people are going to be able to kick out a 300-page petition in 2 seconds. It's not going to be case checked. It's not going to be fact checked. There could literally be 0% of it is true. And we are still going to be required to answer it. We're still going to be required to answer discovery. We're still going to be required to do all these things. And how do we protect our clients, whether they're corporate or individual clients? How can we possibly protect them against the almighty power of intelligence that doubles every few months?
Right.
So
I mean, even in your example of a 300-page petition, and you said like, yeah, we still have to answer it. Yeah, there's mechanisms in place, like for instance, for Texas Rule 91A, we can do a motion to dismiss. But now for that one, I have to address each several points. So your 300-page motion, I'm probably going to hit at least half of that to respond for a motion to dismiss, saying, "Judge, this isn't even real." Let's just be honest here. The judge is like, "Okay, yeah, but how much time did you just pay your attorney to write that 150-page motion to kick out this, illiterate, made-up lawsuit?"
it's going to be cost ineffective, and if we're not careful, it's going to ruin life as we know it professionally. That's the only. It's the law of unintended consequences, right? And so, like, I know there's a lot of joking and everything else about, hey, I made AI, and look, I made a puppy dance or whatever else. Like, I could post some silly AI thing today that I make on Sora.
You had one when you were writing a Bigfoot, I think, at one point. It was pretty funny.
I got one. I was writing a great white. Yeah, just stupid stuff, right? But it's made possible because I can do it on my phone while I'm sitting there doing whatever. Just I type one sentence in and it'll generate a video for me. So it's silly, but at the same time, if you apply that to other things, it starts to get pretty horrifying on the implications. And that's what we're dealing with. And a lot of courts haven't even addressed it yet. So we're dealing with it.
I think they may be the same issue I brought up is how do we define it?
Yeah.
Well, how do you, if we, I mean, like you said earlier, it may have to go case by case basis. I know it when I see it, because as we just pointed out, it doubles, and so eventually it's going to be just everything.
So essentially, the danger of this is becoming like the morality police of AI, because what crosses the line of AI usage for me might be different for you, might be different for Brian, might be different for Todd, and so who's going to determine which line is going to be used? What's moral, what's immoral, what's abuse, what's not abuse? And so that's why we're bringing this to everybody, because before it was don't be a Google lawyer, right? Like don't be a WebMD doctor, don't do these things, but there was a little bit more of a buffer, right? Because people, it's harder to pass a lot of that stuff. Now, that said, people would copy and paste a lot out of Google and put it in pleadings. And that was pretty obvious too. Like that happened a lot, but
at least real cases can show up on, or will show up on Google.
yeah, ideally, right?
Google hallucinates usually.
Not this Varghese thing that we read,
right.
right? Sounds like something. Now I say it out loud, I'm like, is that a Game of Thrones title for
Is
kids?
that Vikings?
Winter was coming, and so as we go, everybody has to be careful. I think lawyers need to be particularly careful, because whether we like it or not, it's going to be our job in one level or another. And I'm not trying to make this melodramatic, but it's going to fall on the lawyer's shoulders to say enough is enough. We need legislation. We need protections. This has got to stop. And some lawyers are starting, but yet again, we don't have a framework yet. So
I think the biggest moral of the story is, if you are someone who is doing this, and it's understandable, it's your case, it's obviously important to you, and you're hiring an attorney, it's great, that's a good start. Maybe show some grace to your attorney when they disagree with you, because maybe what you have isn't real, or isn't the right strategy from that attorney, and they explain, like, well, why do you think it's not? And they can explain it to you why their method of madness is something that they can go with. And if you don't like their strategy, when we said this like on episode 1 or 2, then that's not the attorney for you. That's fine. But that's just how it works.
Or as Brian said at the onset, don't do it.
Yeah.
And if
away.
you do, try to check your own citations. Use Google. Use what other resources you might have, or
Google
hire a
Scholar.
lawyer.
A law library.
Yes.
they still have libraries?
I believe
Yes.
case text is actually free.
Google Scholar.
The librarians there will be very happy to see a human being walk in.
But just do it responsibly. I mean, use the library responsibly, but use everything responsibly, right? So, all right, everybody, thank you so much. Once again, this is Josh Carpenter.
Brian Sherman.
James Metcalf.
Todd Cohen.
And thank you for another episode of The Associates Did It. And we'll catch you on the next one.